Chief Justice, I nearly said Lord Chief Justice, ladies and gentlemen, it gives me great pleasure to welcome everyone present to the lecture in the series which have been held in Cambridge in honour of Sir David Williams. Sir David is present, as you'd expect, and so is John Noland and Michael Russ, both of whom have been generous benefactors of these series of lectures, and we are very grateful to them. Each of these lectures has been given by a hugely distinguished legal figure. Together, those lectures are a testimony of how highly the legal world regards Sir David. However, the lecture tonight is an extraordinary event, even by the standards of those previous lectures. Like the previous lectures, it's being held in honour of Sir David. In addition, the lecture is being held as a part of the celebrations for the 8th anniversary of the founding of this great university. Then it's been given by the Chief Justice of the United States on the subject of Abraham Lincoln, whose bicentenary it is. And the other aspect of the lecture is that President and the Supreme Court. In the very year in which there is to be a new Supreme Court of the United Kingdom, and it's going to open its doors for the first time as the final Court of Appeal of the United Kingdom this October. Although this may not be immediately apparent, there are links between the events to which I've just referred. Like Cambridge University, our legal system can trace its history over 800 years. But until this year, it has apparently developed successfully without the need for a Supreme Court. The younger system of the United States has led the common law world in demonstrating what a Supreme Court can contribute. The explanation for the recent constitutional changes which have taken place in this country, which in turn resulted in the creation of our Supreme Court, could be said to be the developments which have taken place in our administrative law over the recent periods, and which resulted in judicial review undoubtedly becoming, perhaps one might say, an irritant to successive governments, and thus a catalyst for change. Identifying the commencement of those developments is difficult, but personally for me, and possibly also for David Williams, they are linked to the Justice All Souls Review of Administrative Law in 1978. I mention that review in particular because it was the first time I had the privilege, and I so regarded it, of meeting and getting to know David. He was already at that time one of our foremost administrative lawyers, whilst I was about to become a newly appointed High Court judge. But I did share with David his enthusiasm for administrative law, and indeed I was inspired by his example. As our administrative law has developed, so has the stature of Sir David. He's now a legal institution around the world. As an example, just last year, he was the fulcrum of a remarkably successful conference in Hong Kong, convened by this university and the Chinese University of Hong Kong. Like this event, that event was also choreographed by Christopher Forsyth, and I would like to pay credit to him for what a remarkable contribution he made, first at Oxford and now in this university in the field to which I've referred. David, in addition to being a regular visitor to Hong Kong, was a regular visitor to many other parts of the world, and there are many in the audience who have made the journey to be here in honor of Sir David. One of the ways in which he became an institution in the United States were the Anglo-American legal exchanges. And those were exchanges which fed our interest in public law and constitutional law, which at that time was quite a barren area still in the United Kingdom. And the series of these lectures have come from jurisdictions as far away as New Zealand, and there have also been at least 2 other lecturers from the United States Supreme Court. They were attracted to give the lectures because of the esteem in which they in turn held Sir David. Today we have the most senior judge in the United States talking on the relationship between the United States Supreme Court and the President. Such a relationship, and a President, such a relationship is bound to have lessons for us in respect of our Supreme Court. And by a coincidence, I haven't heard any comment about this before, our new court has outside it a statute of Abraham Lincoln. Its presence there was not without controversy. I'm happy to say, not because anyone thought there shouldn't be a statute of that president to mark the completion of 100 years of peace among the English-speaking peoples, but which statute should be chosen. Should it be the one for which the sculptor George Barnard was responsible, or should it be the one created by another sculptor, Saint-Gaudens? This controversy was not of the same dimension or of the same importance as the controversy over whether there should be a Supreme Court of the United Kingdom or whether the House of Lords should remain the home of our most senior court. At the time of the Constitution Reform Act 2005, there was, as it proceeded through Parliament, many matters on which there was not entirely unanimity among politicians and the judiciary. And one of those was certainly whether a Supreme Court should be created. Many of the law lords were reluctant to depart from the law lords' corridor. They welcomed the opportunity that their close proximity to the legislature gave them to be involved in the development of the law, an opportunity which many members of the House of Lords, political or legislative chambers, the legislative chamber, were also welcomed. It was pointed out that the separation of the different arms of government had never been part of our tradition. It was also pointed out that before the United States Supreme Court went to its magnificent building, there had been, in fact, a presence of that august court in Congress. Today, there is no longer controversy over the presence of Abraham Lincoln outside the new Supreme Court. I hope that the time will soon come when the same can be said about the presence of the Supreme Court in Parliament. The position of the Supreme Court and government should not be a matter of controversy. And we are fortunate that the Chief Justice of the United States, who was born as recently as 1955 and became Chief Justice in 2005, has already been immersed not only in that country's judicial system, but also in the workings of government. He'd been a law clerk after he'd left Harvard with a great distinction. First of all, obtaining an A.B., cum laude, and then obtaining a D.J., magna cum laude. Is that the correct answer? Yes. He was a law clerk to two very distinguished judges. One was Judge Friendly, and the other was Associate Justice Rehnquist, before he became Chief Justice, his immediate superior. He had been Special Assistant to the Attorney General, Associate Counsel to President Reagan, White House Counsel, and Principal Deputy Solicitor General in the U.S. Department of Justice. In that capacity, I understood that he argued 39 different cases before the Supreme Court, and the statistics show that he won 25 of them. Appearing as I did for this country's government for 5 years, I wish I could claim I had the similar statistics, but this was the time of Lord Denning, and he had other views. The Chief Justice has also been the judge on the Court of Appeals for the D.C. Circuit, the court in the United States which deals with by far the majority of what we would call public law or administrative law cases. He also, for a substantial period, was in private practice, and again during that period he appeared before the Supreme Court. So what a perfect preparation for the high office he now holds. Chief Justice, we welcome you to give us your insight into the relations between President Abraham Lincoln and the Supreme Court.
Thank you. Thank you very much. Thank you. Thank you, Lord Wolf, for that generous introduction, and thank you all for that very warm welcome. I am honored by the invitation to deliver the Sir David Williams Lecture, which has attracted so many distinguished speakers over the past 8 years. I am reminded of the American general who, early in his career as an officer, vowed that he would not accept any honor that he had not earned. He later found it necessary to revise his thinking and vowed not to accept any honor that someone had not earned. Now, I appear before you this afternoon in that spirit. Someone must have earned this honor, and I am happy to accept it. I feel especially privileged to deliver the lecture this year, which of course marks the 800th anniversary of the founding of this university. I understand that this great institution had its beginnings 800 years ago when scholars migrated to Cambridge to escape the hostile townspeople of another place. Today, when I look out at the university's remarkable buildings and resources and consider the school's rich heritage, I am reminded that, as so often in history, the foresight and wisdom of a few yield so much. The university that began so humbly 8 centuries ago now possesses world-renowned halls and well-stocked libraries. But its stature as one of the world's great institutions continues to reside in those individuals who provide leadership, scholarship, and service to the community. This lecture series honors one of those individuals, Sir David Williams, who has earned well-deserved praise both as an inspiring academic administrator and a distinguished professor. This university has doubtless benefited greatly from Sir William's service as Vice-Chancellor, who also happens to be learned in English law. Now, in my country, the path to leadership, including the office of President, is often through the discipline of the law. In this year, as Cambridge celebrates its 800th anniversary, the 800th anniversary of its founding, the United States celebrates the bicentennial of the birth of Abraham Lincoln, who one historian has described as, quote, more than any other chief executive in the nation's history, a lawyerly president. We celebrate the anniversary of Lincoln's birth not because he was a great lawyer. He was not. But because he was a great leader. I believe, however, that his success as a leader, far beyond what any of his contemporaries could have imagined, was in large part because his life as a leader was grounded in law. Now, in recognition of Sir David's contributions to both leadership and the law, I would like to offer some reflections on Abraham Lincoln, the lawyer, and his relationship to the Supreme Court. When I first visited London, I was surprised to find, as Lord Wolfe has noted, a larger-than-life statue of Abraham Lincoln at Westminster. The statue was presented in 1920 as a gift of the American people to the British people in recognition of a century of peace between our two nations. It was our way of saying that we regarded that business of the burning of the White House in 1814 as water under the bridge. Now, in accepting the statue, Prime Minister Lloyd George said, and I quote, I am not sure that you in America realize the extent to which Lincoln is also our possession and our pride. In his life, he was a great American. He is an American no longer. He is one of those giant figures of whom there are very few in history who lose their nationality in death. Abraham Lincoln belongs to the common people of every land. Now, Lincoln's lineage has been traced to English settlers who arrived in Massachusetts during the 17th century. But Lincoln in his youth could not have been more removed from British influence. He was born in Kentucky to uneducated farmers. Unlike George Washington, John Adams, and other members of the American founders' generation, who were born British subjects and lived within a British-dominated world, Lincoln was the product of the American frontier. He grew up in the sparsely settled but quickly growing states of Kentucky, Illinois, and my home state of Indiana. America's founding generation idealistically saw the unexplored West as a land of unbounded potential. But the promise and possibility could not have been so obvious to young Lincoln. He described himself as, quote, a strange, friendless, uneducated, penniless boy. Lincoln emerged from the frontier into public life almost entirely through his own initiative. He stood out as a young man, and not just because he was 6 feet 4 inches tall. One of his biographers described him as, quote, rail thin, with elongated arms and huge feet, and recounted that he flapped around like some enormous immature bird when he walked. But if he was an odd duck, he was a brilliant one, who obtained an education largely by educating himself. In 1837, he gained admission to the bar. Good moral character was then as now a prerequisite to admission. But in that place and time, it was pretty much the only one and hard enough to find. But in any event, Lincoln, through diligence and industry, became a respected Illinois lawyer. In 1846, he came to Washington as a congressional representative, but he returned to his law practice in Illinois after one term. In 1858, he lost a hotly contested bid for the Senate against the then-renowned Stephen Douglas. But his debates with Douglas brought him to national attention. 2 years later, he obtained the Republican nomination for president and fulfilled Walt Whitman's call for a new quality of leadership. He became the first president born outside the original 13 states at a time when the nation teetered on the verge of disintegration. Lincoln thrust into the role of a wartime president, won re-election in 1864, but was assassinated tragically within 6 weeks of his inauguration and within a week of General Robert E. Lee's surrender at Appomattox, which effectively ended the Civil War. Now, in the course of his career, Lincoln saw the Supreme Court from three different perspectives. As a private attorney, Lincoln appeared before the court as an advocate. As a candidate for the Senate, his campaign turned on criticism of the court's controversial decision in Dred Scott versus Sandford. And as president, Lincoln found himself subjected to the constitutional constraint of Supreme Court judicial review. And at the same time, he exercised his constitutional power to nominate and appoint individuals to serve on the court. In each of those instances, Lincoln's contemporaries might have readily concluded that Lincoln was not particularly successful in his dealings with the court. But in each encounter with the court, he displayed what we have come to regard as Lincoln-esque virtues that illustrate why he is so widely admired among Americans. Where Lincoln grew up in Indiana, there was no clearly marked path to the Supreme Court. Lincoln's biographers recount that he first developed an interest in the law as a teenager by traveling to the much more modest courthouse in Boonville, Indiana, to watch civil and criminal trials. In small western communities of that sort, the local courtroom was one of the few sources of entertainment. Now, Lincoln eventually decided to pursue law as a vocation, and like many lawyers of the early 19th century, he took his lessons from Blackstone. But Lincoln did not come to Blackstone. Blackstone came to him. Before taking up the law, Lincoln ran a small store where he bought and sold goods. As an accommodation to a settler who was moving farther west, he agreed to buy an old barrel filled with discarded items. Lincoln later told how he emptied the barrel and found buried at the bottom a complete edition of Blackstone's commentaries. In short, Lincoln found Blackstone by literally scraping the bottom of a barrel, and that discovery launched his legal career. Like almost every lawyer in America of that era, Lincoln did not attend college or law school. He read legal treatises and apprenticed with other lawyers, relying on self-education and an extraordinary memory. Lincoln once said that he had a mind like steel. It was difficult to make a mark on it, but once a mark was etched into it, it was hard to remove. He was not only self-educated, but continuously self-educating, mastering books as he acquired them, ever increasing his eclectic canon. Lincoln was born in the same year as Gladstone and Tennyson, and on the same day as Charles Darwin, and he had a special attraction to British authors and poets, including Thomas Gray, Shakespeare, and Lord Byron. He savored learning, but his modest frontier upbringing also taught him how to communicate with jurors, regardless of class or education. He grew up in communities where people were already isolated in so many ways, and they simply could not afford to be insular with each other. He probably learned early in life the value of taking careful measure of friends and neighbors and getting to the heart of their concerns. This skill not only enabled him to make a case understandable to jurors, but also allowed him to find a basis for compromise and to achieve settlement wherever possible. On one renowned occasion, a client asked Lincoln to represent him to recover $5 that he had loaned to a neighbor. Lincoln told the man that the cost of the suit would exceed the $5 and that he should drop it. But the man said he wanted to teach the debtor a lesson. So Lincoln agreed to handle the matter and said his fee would be $10 payable in advance. Lincoln then gave the debtor $5 with which to repay what he owed and kept the rest. Lincoln never traveled to England, but given his sociable nature, his keen intellect, and his good sense of humor, he would have been good company at one of the great English inns of court, including the one that shares his name. Lincoln, though, is an unlikely descendant of that inn's reputed namesake, Henry de Lacy, 3rd Earl of Lincoln, and he surely lacked any aristocratic airs. On one occasion, Lincoln met an English aristocrat who expressed astonishment that Americans shined their own shoes. Lincoln replied, "Would gentlemen in England not do that?" The Englishman answered, "Certainly not." Lincoln's response, "Then whose shoes do they shine?" In any event, like many American litigators of his day, Lincoln's career took him to a different sort of inn. Lincoln matured in his profession by traveling on circuit with judges as they went from county courthouse to county courthouse. Judges set out on circuit as soon as the winter thaw made the roads passable, and lawyers followed in their wake. sharing lodging with a rough crowd in the town taverns. As a result of his circuit riding, Lincoln soon developed a widespread reputation among his contemporaries as one of the best jury lawyers in Illinois. He was extraordinarily industrious. In a span of 24 years, he handled more than 5,000 cases and appeared more than 200 times before the Illinois Supreme Court. Lincoln has the reputation as a trial lawyer whose homespun nature won over the uneducated juries. But the record of his one appearance before the Supreme Court of the United States shows that he was also a sophisticated appellate attorney who could present technical arguments to a learned bench. Lincoln's appearance as an advocate before the Supreme Court grew out of an exceedingly technical dispute bearing the name Lewis against Lewis. The plaintiff had purchased a tract of land but was ejected from a portion of it because of a defect in the title. The plaintiff sued the seller for damages, but the seller had died, and the administrator of the seller's estate, whom Lincoln represented, argued that a state statute of limitations barred the suit. The statute of limitations, however, had an exception that would extend the time period for filing the suit while the plaintiff was out of state. Now, this already sounds like an exam question, but there is more. The state legislature had repealed the exception, and the narrow question before the Supreme Court was the effect of the repeal. Did the statute of limitations run from the date that the cause of action accrued, in which case the limitation period had run and Lincoln's client would win, or did it run from the date of the repeal of the exception, in which case the suit was timely and the action against Lincoln's client could proceed? Now, a transcript of Lincoln's argument does not exist, but at the Supreme Court we have in our collection Lincoln's handwritten notes for this case. Although Lincoln was serving his one term in Congress at the time, it was quite common for members of Congress to go down to the basement of the Congress building where the Supreme Court sat. Lincoln did not approach his argument as a politician or in any way casually. His notes reveal an organized and analytical mind, a lawyer's mind. Lincoln methodically set down the relevant dates of the land dispute. He laid out the structure of his argument, and he listed, with case descriptions, the relevant Supreme Court authority. Even more interesting, however, was the portion of his notes dealing with his argument on the interpretation of the statute of limitation. In setting out his statutory construction argument, Lincoln first wrote, in an impeccable handwriting, "Examine nature and objects of acts of limitation." But he then crossed that out and replaced it with the note, "Examine the statute itself, its language and its provisions as to taking effect." He underscored the word language. Now, some of my colleagues might cite that change as evidence that Lincoln, like Paul on the road to Damascus, underwent a life-changing conversion to textualism. But I think it more likely that Lincoln was simply a pragmatic advocate. He examined the available arguments and concluded that a textual argument would most likely advance his client's case. But even if that was his best argument, it was not good enough. The court, in an opinion authored by my unfortunate predecessor, Chief Justice Taney, ruled against Lincoln's client. Taney relied not on the statute's text, but on the objects and purposes of the statute. This would not be the last time that Lincoln and Chief Justice Taney would find themselves at odds. Lincoln did win the vote of Justice McLean, who urged in dissent that Chief Justice Taney's decision effectively overruled controlling precedent, and this would not be Lincoln's last encounter with Justice McLean either. So Lincoln, like many very good lawyers, lost his one and only case before the Supreme Court. The case was, of course, not of great public importance then or now, but the case reveals Lincoln's character as a lawyer. He was a disciplined craftsman who took great pride in his work, regardless of whether the stakes were great or small. He was unsuccessful in securing the desired result, but he did not fail for lack of effort or ability. He represented his client with zeal and conviction, and, at least as can be judged from his notes and the work that went into them, he demonstrated the diligence, clarity of thought, and good judgment that distinguishes great lawyers on both sides of the Atlantic. Now, Lincoln came to national attention because of his campaign against Stephen A. Douglas for a seat in the United States Senate. The central issue of that election was slavery. Lincoln had long believed that slavery was morally wrong, but he saw legal and practical impediments to its immediate abolition. He believed that slavery could be put on a course of eventual extinction if Congress refused to allow slavery in the Western territories that in the future would become states. Douglas, by contrast, was untroubled by the moral question and had voted as a senator to allow new states to choose for themselves whether to allow slavery. During the Senate race, the Supreme Court weighed in on this volatile issue through its decision in Dred Scott versus Sanford, the greatest self-inflicted wound on the court. Dred Scott was a slave who brought suit in state court claiming that his servitude was extinguished as a matter of state law because his owner had taken him to federally owned territory where slavery was unlawful. The state courts rejected that suit, and Scott then brought a federal suit pursuing his claim. The Supreme Court could have decided the case on a number of narrow grounds. Instead, the court used the case as a vehicle to rule broadly as a matter of constitutional law